Welcome to Ask the Expert with noted radio host Steve Sleeper. Each week, Steve interviews entrepreneurs and professionals and shares their intriguing stories of success and service. Now, here's radio veteran Steve Sleeper.
And today on Ask the Expert, we're speaking with Susan Olive with Olive & Olive in Durham, North Carolina. She's an intellectual property attorney. Susan, how are you today?
Just fine, thanks. Steve, how are you doing?
I'm good. Hey, tell us a little bit about yourself and your firm.
Well, our firm has been around since about 1957, so a good bit more than half a century. It was founded by my father to begin with, and we've now got about 6-7 of us in here, along with a good staff of professional paralegals and so forth, all of us working in the field of intellectual property law and doing nothing but that.
Okay, so what is intellectual property law?
Well, if you think about the words that go into it, intellectual property, it is exactly what it sounds like. Intellect is a mind or an intelligence, especially a really superior one. And property is something that's owned. And so intellectual property and intellectual property rights are the rights that are created by people using their own imagination and intellect.
Okay, so I believe then that this involves copyright and trademark and patents. Am I correct in saying that?
That's right. We work with to protect and to enforce patents, trademarks, copyrights, and trade secrets that are owned by our clients, or when they're accused of infringing those rights owned by somebody else.
Okay, so what's a copyright?
Well, a copyright is a form of protection granted by the United States Constitution that protects the way in which people express the ideas of their mind. For example, artists express ideas by drawing or sculpting. Writers express those ideas by writing. Computer programmers express them by writing computer programs in particular. Those are the types of things. Dramatists write plays, songwriters write lyrics and music. All of those things come under the scope of copyright.
Okay, how about now? What's a trademark then?
Trademarks protect the symbols, colors, or other insignia by which members of the public can identify their goods, the goods or services of one provider, and distinguish them from the goods or services that are being provided by somebody else. A really easy to identify example these days, at least, the golden arches of McDonald's. If you see those when you're driving down the street, you know you're getting a McDonald's burger and you're not going to be getting one from Wendy's or another chain.
Okay. Trade secret.
Trade secrets are things, intellectual or otherwise, that have value, commercial value, because they are kept secret. Examples that everybody has heard of are the Kentucky Fried Chicken recipe for the special spices that go into making their chicken, or Coca-Cola's formula for Coca-Cola. But companies have many other types of trade secrets, and it may be customer lists, for example, that have value because their competitors don't know who those customers are. Ways of making products often are kept secret. The way in which you line up people on a factory line, the order in which particular components are manufactured may be more efficient when done one way than done another way, and you have an advantage over your competitor because you know those ways that you've worked out over time, and you don't want them to find them out.
Okay. So one thing I've heard about is trademark searches. Now, what's the value of doing that?
Well, trademark searches are performed so that you will know whether or not your trademark, the one you're planning to use, is already being used by somebody else. And worse yet, if it's registered federally by somebody else, because if it is, you're not going to be able to use it if there's a likelihood that your use would cause confusion with that of the prior user. So you can avoid a lot of trouble by searching first before you choose your trademark.
Okay, let's talk a little bit about patents then. How long does it take to get one, and how long does it last?
Well, it takes The United States Patent Office goal is that it should take 18 months from the time that you have filed a patent application until you get one. They rarely meet that goal. Often it can be 2 years, sometimes more than that. Occasionally they'll be faster. And predicting exactly how fast it's going to be is extremely difficult because it's dependent on government funding and how many examiners they have at any one time.
Oh.
Once you get a patent, it's good for 20 years from the date you first applied for it. If it's a normal patent, what people think of as patents, utility patents are what those are called. And if it's a design patent, then it's good for 14 years from the date that you got the patent.
Okay, now let's say I've invented a better widget, okay, for lack of a better way of putting it. How do I find out if my invention is unique?
Well, you can perform searches, and right now we encourage our clients to do some self-help by going to the United States Patent Office online website and searching there using terms that would normally be used, putting it in a box that looks a whole lot like a Google search box or another Yahoo search box or somebody else's search box, and seeing what comes up, then looking at those patents and seeing whether they do or don't show the same thing. It's not a perfect science. Searching is an art as well as a science. And the problem is that when you've got a widget, it might be called a nail, it might be called a screw, it might be called a fastener, it might be called something else. So the more searching you do, the more likely you are to know the most likely terms that somebody who's invented something similar to yours might have used. But it will never be completely perfect because it's never possible to predict every single word that somebody might have used to describe your invention or how long ago they might have filed their application. And, Abraham Lincoln got patents. So,
wow.
These things go back a long ways.
Yeah, they sure do. So is that part of the process then? I've done my research and everything. I apply for the patent, and does the government do some research to see if it's unique, or how does that work?
Yep, the government assigns an examiner to your patent application after it's filed. That assignment of an examiner will typically take at least 6 months and can take up to a year or more before someone even gets assigned to look at your application. But the first thing they do after they look at it and make sure that you didn't leave anything out that you were supposed to have included when you applied is to do a search to see whether or not it is, in fact, new and non-obvious in view of what's been done before. And they do that the same way, essentially, that we're recommending, which is that they do word searches. They also look using slightly more complex methods, which involve knowing what area your patent would fall into. For example, excuse me, animal traps of the victim reset type have their own classification. So if you've invented an animal trap where an animal walks out on a gangplank and then falls in a bucket and drowns, that is an animal trap of the victim reset type, and all of them will be classified in a particular classification, and the examiner would look in that particular classification to see what else has been invented that has to deal with that particular type of invention.
Oh, okay. So I've applied for a patent for my widget, and I've received my patent. Do I have to do anything to protect that patent then over the course of the next 20 years?
Well, what you have to do and what you're able to do can vary somewhat, and the law pertaining to that changes from time to time. But generally speaking, if someone has infringed your patent, that is, taken your invention and used it without your permission, then you typically can go after them anytime within 6 years after they commit these infringing acts, and you're entitled, if you can prove that they did in fact infringe your valid patent, you're entitled to recover damages from them. If they did it willfully, you may be even be able to incur, if they infringe your patent willfully, you may be able to recover attorney's fees and enhanced damages, sometimes 3 times the amount that they profited from use of your invention.
So this would apply not only to patents, but copyrights, trademarks, and trade secrets. Then, if somebody infringes on that, you can file suit, and I would imagine that part of that lawsuit process is proving that they in fact did infringe on it.
Yes, you're correct that you can always sue if someone infringes your rights. B, if you've got an issued patent, a federally registered trademark, or an issued copyright registration, the latter being one that was issued within 5 years from the date you first created your work. In all of those cases, there's a presumption that the registration or patent, as the case may be, is valid. And so you go into court with the presumption that you have valid rights and all you're doing is enforcing. So your burden is to show that the other people infringed. If for some reason you don't have government issued rights, for example, in a trade secret case or in a copyright case where you waited a really long time to get a copyright registration, or in a trademark case, if you don't have a trademark registration or didn't have one before the infringement started, then you've got to prove that you actually have valid enforceable rights.
Okay. Now, one thing that I heard is that if somebody infringes on a copyright or trademark or trade secret or patent, regardless of intent, you really do need to file suit on that, because you need to show that you want to protect that trade secret, copyright, trademark, patent. Was that correct in what I heard?
What you heard is absolutely correct, as far as if you want to sue the same person for the same infringements, because you can lose rights by waiting too long after you know about somebody's infringement if you don't enforce your rights.
Okay.
If what you've got, though, is you're here in North Carolina, where we are, and somebody out in Seattle, Washington is infringing your trademarks by operating a little mom and pop shop out there that doesn't go outside of Seattle, perhaps, and they don't even have an internet website. You found out about them because your Aunt Susie was on vacation and told you. That person is not actually causing confusion, typically, with your trademark rights nationally or in North Carolina, and so you can wait to sue them until such time as they actually start causing confusion, if they ever do. You don't have an obligation to enforce your rights against people who aren't actually causing you any damage.
Okay. Yeah, and that answers my question, and that's how I was trying to phrase it. Now, you're in North Carolina. Now, most attorneys that I speak to are licensed in a state or two. Is that the case with intellectual property law, or how does that work?
We are licensed within a particular state, in this case, North Carolina, and many of us have licenses in other states as well. But for federal rights that are enforced in federal court, and federal applications that are where the applications are processed by federal agencies, those are not dependent on state licenses and instead are dependent on the rights that are granted by the various federal agencies or the federal courts. Typically, our firm actually has clients from all around the world as well as all around the country, and we've brought suits or defended suits everywhere from foreign nations to other states within the United States, California, Minnesota, wherever our clients' rights happen to be in trouble.
And is the most important thing in looking for an intellectual property attorney, I'm going to guess the most important thing is somebody like you that focuses exclusively on that, because there's a lot to know. Is there anything else we should be looking for?
Well, you want somebody that you can understand and that can understand you. Sometimes that means if you've got a really complex technology that you'd like somebody who has a background in your particular technology. Other times it's a matter of being able to understand what they do and they're being able to communicate with you. For example, I have an undergraduate degree in chemistry. And if you don't have at least some background in chemistry, it's pretty hard to understand what an alcohol is, what an ester is, and when somebody starts talking about those terms, to understand what they do. I mean, I did work in engineering, and when people talk about resistors, old style, yes, but nonetheless still in use in a number of areas, you understand what are. If you've learned about lasers, and we do a lot of patents on lasers and laser technology and so forth, and you understand about the different light waves and what makes light straight as it goes to attack something, where heat is and isn't a problem, those types of things. Or boats, we do a lot of work in boats because there's a lot of boating technology in North Carolina, and just understanding how the fiberglass gets put on those boats and the types of problems that they can have, and why small things that you might not realize are important on land actually make a huge difference when you're out on the water on navigable seas. Those are important things, and you'd like to have somebody who understands that, or who's willing to learn it.
Yeah, okay, yeah, that makes a lot of sense. Susan, how do we reach you?
Well, we've got a website online at oliveandolive.com with the AND spelled out. Our telephone number is 919-683-5514. And when people call our office or when they communicate with us by email, they need to understand that before they actually talk to an attorney, they go through an intake process, because all lawyers should, and certainly intellectual property attorneys especially, need to be careful about not accepting conflicting clients. So we do a lot of litigation. We don't want to be taking both sides of a case. We work on a lot of patents and trademarks. We don't want to be taking on two clients who are trying to use the same mark or trying to invent exactly the same types of products, because we want to be sure that we don't transfer information from one client to another, even unknowingly. So the first step when someone wants to contact us and talk to us is that our intake specialist talks to them, finds out what they are, and does a conflict check to make sure that we aren't going to be taking on a client for whom we could not give our best efforts and for whom we couldn't guarantee that we're going to actually do a good, non-conflicting job of work.
A lot of great information today, Susan. I really appreciate it. And speaking of information, I noticed that you have a number of articles on your website at oliveandolive.com, A-N-D, oliveandolive.com. So that's always good stuff to read. And our guest today on Ask the Expert has been Susan Olive with Olive and Olive Law Firm and intellectual property attorneys in Durham, North Carolina. Susan, this has been fun. Thanks a lot.
Thank you. Appreciate it.
Thanks for listening to Ask the Expert with Steve Sleeper. Join us next time as entrepreneurs and professionals share their intriguing stories of success and service.